Given the testimony presented, the defense moves for a directed verdict. The court will take that under advisement.
Therefore, based on the overwhelming evidence presented by the prosecution, we ask this court to find the defendants guilty on all counts.
We must ensure that the translation accurately reflects the testimony provided. Does the interpreter confirm the statement?
Confirmed, Your Honor.
I saw it with my own eyes. Men, women, children. And they want me to be silent about what I witnessed. I will not be silent.
On the morning of November 20th, 1945, in a courtroom in a German city that had been reduced to rubble by Allied bombing, 21 men sat in a wooden dock and faced charges that had never been brought against anyone in the history of human civilization. Not charges of murder, though murder was among them. Not charges of theft or destruction, though those were there too. The charges were something new, something that the lawyers who wrote them had invented in the months since the war ended. Something that the defendants and their lawyers argued had not existed as law at the time the acts were committed, and therefore could not legally apply to anyone. The charges were crimes against peace, war crimes, and crimes against humanity. And the men in the dock were the surviving senior leadership of the government that had started the war, occupied Europe, and killed millions of people in a systematic program of industrialized murder that had no precedent in history. The Nuremberg trials were the most important legal proceeding of the 20th century. Not the most dramatic, though the drama was real, not the most technically accomplished. The improvisation and the gaps in the legal framework were visible to every lawyer in the room. The most important, because what happened in that courtroom between November 1945 and October 1946 established something that had not previously existed. The principle that individuals, not just states, not just armies, but individual human beings with names and faces and choices, could be held legally accountable for crimes committed in the name of their government. That principle changed international law. It changed the concept of sovereignty. It created the foundation on which the International Criminal Court and the concept of universal jurisdiction were eventually built. And it was not inevitable. It was a choice made under pressure by people who disagreed about whether it was the right choice, who had alternatives available to them that were simpler and in some ways more satisfying, and who chose the harder path because they believed it was the right one. The alternatives to a trial were real and were seriously considered. The Soviet Union, which had the most immediate and visceral stake in the punishment of the Nazi leadership, initially favored summary execution, identifying the senior Nazis, confirming their identity, and shooting them. This approach had the virtues of speed, certainty, and the kind of decisive finality that the scale of what Germany had done seemed to demand. Winston Churchill, at various points in the war, had favored something similar, a list of war criminals, execution without trial, justice by decree rather than by law. The argument for this approach was not simply bloodthirstiness. It was a genuine concern that a trial would give the defendants a platform, would create a spectacle in which skilled lawyers could muddy the waters and cast doubt on evidence that was, in the minds of those who favored execution, simply not in question. We know what they did. We know they did it. Why give them the opportunity to argue otherwise? The Americans pushed for a trial. Henry Stimson, the Secretary of War, was the most influential advocate for the legal approach, a man who had spent his career as a lawyer and who believed, fundamentally, that the rule of law was what separated the Allied cause from a Nazi cause. If the Allies executed men without trial, they would do what the Nazis had done, deciding that certain people's lives could be ended by decree, without process, without the opportunity to answer the charges against them. The symbolism of that equivalence was intolerable to Stimson and to others who shared his view. The trial was not just about punishing the defendants. It was about establishing, in the most public and deliberate way possible, that a different kind of world was being built. A world in which the rule of law applied even to the most powerful, even to the victors, even to people who had won the right to decide what happened to the losers. The legal framework that was constructed for the Nuremberg trials was the work of months of negotiation between the four Allied powers, the United States, Britain, France, and the Soviet Union, each of which had different legal traditions, different conceptions of criminal procedure, and different political interests in how the trials would be conducted. The London Charter of August 1945, which established the International Military Tribunal and defined the charges, was a compromise document, a document that tried to bridge common law and civil law traditions, that tried to balance the American insistence on a full adversarial proceeding with the Soviet and French preference for a more inquisitorial model, that tried to define crimes that had no prior definition in international law, without making the entire exercise look like retroactive. Legislation. The retroactivity problem was the most serious legal challenge to the entire enterprise, and the defendants' lawyers raised it with skill and persistence. The argument was simple. The crimes for which the defendants were charged, crimes against peace, crimes against humanity, did not exist as defined crimes under any law in force when the defendants committed their acts. International law in 1939 did not prohibit aggressive war in terms that created individual criminal liability. The concept of crimes against humanity, the systematic persecution and murder of civilian populations, had no established place in the law of war as it existed before 1945. Punishing people for acts that were not crimes when committed is, in any legal system that takes the rule of law seriously, a fundamental violation of the principle of legality. You cannot convict someone of breaking a rule that did not exist when they broke it. This is the moment I want to ask you to subscribe if you haven't already. The Nuremberg trials are one of the hinge points of modern history, a moment when the world had a choice about what kind of precedent to set, what kind of institutions to build, what kind of principles to establish. If these stories matter to you, subscribe and share this. Back to Nuremberg, back to the argument about retroactivity, and the answer the prosecution gave to it. The human beings who conducted the Nuremberg trials, the judges, the prosecutors, the defense lawyers, the translators, the court reporters, were themselves product of a world that had just emerged from the most destructive conflict in history, and their work at Nuremberg was shaped by that experience in ways that the formal legal record does not fully capture. Robert Jackson had been Attorney General of the United States before his appointment to the Supreme Court. He was a man of the law in the deepest sense, someone who had spent his career believing that the rule of law was the essential foundation of civilized society and that the commitment to legal process, even in the most extreme circumstances, was not a weakness, but a statement about what kind of society you were building. His decision to leave the Supreme Court for Nuremberg was not universally approved. Chief Justice Harlan Stone wrote that the Nuremberg trial was a high-grade lynching party, but Jackson believed it was necessary, and he believed it could be done right. His opening statement, delivered on November 21st, 1945, is one of the great documents of 20th century legal rhetoric. He was speaking to defendants, to the Allied judges, to the German public, to the international press, and to history simultaneously, and he found a register that was appropriate for all of those audiences at once. He described what the prosecution intended to prove: the planning and waging of aggressive war, the violation of the laws and customs of war, the crimes against humanity, with the precision and the organization of a skilled lawyer. And he framed it in terms that established what was at stake. Not just the punishment of these specific defendants, but the creation of a legal precedent that would serve the future. The Soviet prosecutors who sat alongside the Americans and the British and the French brought their own traditions and their own priorities to proceedings, and the tensions were real and occasionally visible. The Soviet approach to criminal procedure was different, more inquisitorial, less concerned with protection of defendants' rights, more comfortable with the use of political trials as instruments of state policy. The Soviet insistence on including the Katyn massacre in the indictment as a German crime created a specific problem that the other Allied judges navigated by simply declining to address it in the judgment. The Cold War was already beginning, and the legal proceedings at Nuremberg were conducted in its shadow. The defense lawyers at Nuremberg, German lawyers operating in a framework that was foreign to their legal training, defending men whose acts were indefensible in any common moral framework, using arguments that they knew were unlikely to succeed, performed a professional obligation with thoroughness that the tribunal ultimately respected, even where it rejected their arguments. Otto Stamer, who defended Göring, was skilled enough to score genuine points in cross-examination and construct a coherent defense that made the legal issues visible. Hermann Jarius, who presented the defense's arguments on the retroactivity and victor's justice issues, made arguments that have been taken seriously by legal scholars ever since, even by those who ultimately reject them. The interpreters and translators who made the multilingual trial possible deserve their own recognition. The simultaneous interpretation system was a technological and human challenge that had never been attempted at this scale. The interpreters worked in rotation, typically in 15-minute stints, because the concentration required for simultaneous interpretation, processing one language while producing another, maintaining the pace and tone of the original speaker, is cognitively exhausting in a way that makes long, continuous sessions impossible. The specific challenge of interpreting testimony about mass murder, of translating the bureaucratic language of genocide into 4 languages simultaneously while maintaining professional composure, was not something the interpreters had been trained for. They did it. The physical experience of being at Nuremberg, in the courtroom, in the prison, in the bombed-out city where the trial was happening, was something that all of the participants described as unlike anything they had previously experienced. The defendants were there every day, in their dock, available to be observed at close range by the prosecution, the judges, the press, and the public. The banality that Arendt would later describe as characteristic of Eichmann was visible at Nuremberg too. Men who had commanded or participated in the murder of millions sitting in a courtroom, following the proceedings, conferring with their lawyers, eating their meals, going to sleep at night. The normality of their daily behavior in the dock was, for many observers, as disturbing as anything in evidence. Hannah Arendt was not at Nuremberg. She covered the Eichmann trial in Jerusalem, but her concept of the banality of evil resonates as much with the Nuremberg defendants as with Eichmann. The men in the dock had not been monsters in the sense that fairy tales use the word. Creatures of a different order, visibly malevolent, distinguishable from ordinary human beings by their appearance or their behavior. They had been politicians, bureaucrats, military officers, lawyers, businessmen. They had held dinner parties and written letters to their families, and had opinions about music and attended church. The capacity for atrocity that they had demonstrated was not the capacity of a different species. It was a human capacity, a capacity that exists in human beings, and that specific institutional and political context can bring to the surface in specific ways. That observation, the most disturbing conclusion that Nuremberg and the subsequent reckoning with the Holocaust have produced, is the one that matters most for the future. The Nazi crimes were not produced by monsters. They were produced by human beings operating within a specific institutional framework, in a specific political context, shaped by a specific set of ideological commitments, enabled by a specific set of choices and failures of resistance. The same human beings in different circumstances might have led entirely different lives, and the same human capacity for atrocity that they manifested exists in human beings in every society and every era, available to be mobilized by the right combination of ideology and institutional permission, and the specific social dynamics that make people willing to do things they would not otherwise do. Nuremberg was an attempt to establish a legal framework that would make the mobilization of that capacity harder, that would create accountability, establish deterrence, and build a norm of individual responsibility that would make people in positions of power think twice before participating in crimes against humanity. It was an imperfect attempt. The framework it established is imperfect. The world it helped create is imperfect. But the attempt was genuine, and the imperfection does not erase what was accomplished. The wrongs which we seek to condemn and punish have been so calculated, so malicious, and so devastating, that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Jackson said that in 1945. It remains true in 2025. The Nuremberg trap is still closing, slowly and imperfectly, and not always on the right people. But it is closing. And the fact that it exists, the fact that the principle of individual accountability for crimes against humanity is part of international law, that there is an institution dedicated to its application, that the norm is established even if its enforcement is incomplete, is because in 1945, when it would have been easier to shoot the defendants and be done with it, the Allies chose the harder path. That choice was right. The survivor testimony that emerged from the Nuremberg proceedings and from the subsequent trials, particularly the Eichmann trial, represented a shift in how the Holocaust was understood and communicated to the public. The initial post-war years had been characterized by a kind of stunned silence about what had happened, a silence that was partly the product of grief and trauma and partly the product of a public culture that was not yet ready to receive the full account. The trials, with their systematic documentation of the evidence and their platforms for survivor witnesses, began the process of making the Holocaust a specific, detailed, human reality rather than an abstraction. The testimony of Rudolf Haas at Nuremberg was among the most devastating single pieces of evidence in the entire proceeding. Haas was the commandant of Auschwitz-Birkenau, the largest of the death camps, and he testified with the calm specificity of a man describing operational details rather than the murder of millions. He described the capacity of the gas chambers, the daily operational routines, the procedures for selection, the management of the crematoria, the logistical challenges of disposing of the bodies in quantities that the camp's operations produced. He did not express remorse. He expressed professional pride in his operational efficiency. His testimony was not the testimony of a monster, or rather, it was a testimony of a man who had made himself into a functionary of murder, who had organized and administered one of the most lethal operations in human history with the mentality of a competent manager, and who could describe what he had done without the emotional register that the acts described seemed to demand. The Haas testimony was, in its own terrible way, exactly what Hannah Arendt was later describing in her account of Eichmann, the horror of a bureaucratic mentality applied to the most extreme circumstances imaginable, the capacity of human beings to participate in atrocity while maintaining the self-understanding of a responsible professional doing his job. It was also, from the prosecution's perspective, perfect evidence, detailed, specific, internally consistent, impossible to dismiss or minimize. The concentration camp survivors who eventually testified at Nuremberg and at subsequent proceedings gave a different kind of testimony. Where Haas described the Holocaust from the perspective of its administrators, the survivors described it from the inside. The specific details they provided, the selection on the ramp, the stripping of clothing and valuables, the shaving of heads, the separation of families who would never see each other again, the knowledge of what the smoke from the crematoria meant, the specific acts of violence and degradation that filled the daily life of the camps, created a record of human experience that no documentary evidence could replicate. These were not statistics. These were people describing what had been done to them and to the people they had loved. The decision about how much survivor testimony to include in the Nuremberg proceedings was a matter of strategic calculation for the prosecution. Jackson and his team were primarily building a documentary case. They had the documents, they had the films, they had the organizational evidence of machinery of the Holocaust. Survivor testimony added human dimension, but also introduced variability and the possibility of inconsistency that a defense lawyer could exploit. The subsequent trials, particularly the Eichmann trial, made a different calculation, one that prioritized the human dimension and built a record of survivor experience that has remained central to Holocaust documentation ever since. The question of what the perpetrators knew and when they knew it, a question that the Nuremberg defendants raised in various forms as part of their defense, was addressed by the evidence in ways that established definitively the extent of knowledge within the Nazi leadership. The final solution, the decision to murder all European Jews, had been discussed at the WWII conference in January 1942, the minutes of which were among the documents captured by Allied forces. The minutes were introduced at Nuremberg and became one of the most important single documents in the historical record of the Holocaust. They showed, in the bureaucratic language of a high-level government meeting, the systematic planning of mass murder, the coordination of transportation, the allocation of personnel, the discussion of methods with a matter-of-fact tone of men conducting routine government business. The WWII protocol is not the only evidence of high-level knowledge and planning. The documents of the Holocaust are extensive and detailed, reflecting the bureaucratic culture of the regime that produced them. But it has a particular significance as a symbol of the specifically administrative nature of the final solution. The fact that it was not a spontaneous outbreak of violence, but a planned, organized, systematically implemented program that required the cooperation of multiple government agencies and a substantial portion of the German state apparatus. The Nuremberg trials were also, from the beginning, a public relations exercise as well as a legal proceeding, an exercise in constructing a historical narrative that would serve the Allied powers' interests in the post-war world. The decision to make the record public, to publish the transcripts and the evidence, to allow press coverage, was a deliberate choice to shape how the Nazi crimes would be understood and remembered. The Nuremberg records, millions of pages of documents, hundreds of hours of testimony, became the foundation of Holocaust scholarship and of the post-war understanding of what had happened. The trial also served to transfer the burden of knowledge from the Allied governments to the German public and to history. Before Nuremberg, the full extent of the Nazi crimes was known to relatively few people outside the German state apparatus. The deliberate extermination program, as opposed to the general violence and repression that had been widely known, had been concealed from the German public to a significant degree, and from the international public almost entirely. Nuremberg made concealment impossible. The evidence was on the public record. The denial that would characterize certain fringes of post-war politics was denial of something that had been established in a court of law with documentary evidence and witness testimony. Not historical opinion, not interpretation, but legal finding. The political context in which the trials took place, the emerging Cold War between the Western Allies and the Soviet Union, created tensions that were visible throughout the proceedings and that shaped their outcomes in ways that the legal framework alone could not fully account for. The Soviet Union's participation in the tribunal was complicated by the fact that the Soviet Union had itself committed acts that would have been prosecutable under the Nuremberg framework: the Canton Forest massacre of Polish officers in 1940, the deportation of populations from the Baltic states and other occupied territories, the treatment of German prisoners of war. The Soviet prosecutors at Nuremberg attempted to attribute the Canton massacre to the German defendants, an attribution that was false and that the other Allied judges were unwilling to endorse, leading to one of the more awkward moments of proceedings. The American, British, and French governments were not without their own vulnerabilities. The strategic bombing campaigns that had destroyed German and Japanese cities, killing hundreds of thousands of civilians, could be characterized as targeting civilian populations in ways that the Nuremberg framework defined as illegal. The use of nuclear weapons against the civilian populations of Hiroshima and Nagasaki, acts that occurred before the Nuremberg judgment was delivered, had no legal defense under the principles being articulated in the Nuremberg courtroom. The victor's justice critique gains its force from exactly these observations. The Nuremberg framework was applied selectively to the crimes of the defeated, not universally to the crimes of all parties to the conflict. The response to this critique is not that the critique is wrong, it is substantially right, but that the alternative to selective justice is no justice at all. The choice in 1945 was not between perfect universal justice and imperfect selective justice. The choice was between imperfect selective justice and letting the perpetrators go. Stimson's argument that a trial, even an imperfect one conducted by the victors, was better than summary execution or impunity, was right, even knowing what the trials would and would not accomplish. The legacy of Nuremberg in the specific context of German national identity is one of the most studied and contested subjects in post-war European history. Germany's engagement with the Nazi past, the willingness, eventually, to confront what had been done in Germany's name, to build museums and memorials, to incorporate the Holocaust into the educational curriculum, to prosecute war criminals decades after the fact, represents an extraordinary example of society taking responsibility for its history. It was not easy, it was not complete, and it did not happen all at once. It happened over decades, driven by successive generations of Germans who found different relationships to the past and who demanded different degrees of reckoning from their institutions. The Nuremberg legacy is also visible in the specific German legal system's approach to Holocaust denial and to the expression of Nazi ideology. German law criminalizes Holocaust denial and the public display of Nazi symbols in ways that reflect a specific national judgment about the relationship between free expression and historical responsibility, a judgment that is different from the American approach and that reflects a specific German experience of what happens when certain kinds of speech go unchecked. The trials that followed Nuremberg's precedent, the Yugoslav Tribunal, the Rwanda Tribunal, the International Criminal Court, have been imperfect in their application and in their outcomes. They have prosecuted some perpetrators and failed to reach others. They have confronted political obstacles that limited their effectiveness. They have been criticized, with some justice, for their selectivity and their costs. But they have also established a record of the siege of Sarajevo, of the Rwanda genocide, of the Darfur atrocities. That makes denial harder and impunity less comfortable than it would otherwise be. The standard exists even when it is not fully applied. The expectation of accountability exists even when accountability is partial or delayed. That is the Nuremberg trap, not a trap for the defendants, though it was that, a trap for the future, for any government or any military that commits crimes against humanity, a trap that says there's a legal framework, there are standards, there's a record, and the possibility of judgment exists even if it is not immediate. The trap is imperfect, and the catches it makes are selective. But it closes over those it catches with finality that summary execution never achieved, and that impunity, by definition, cannot. Robert Jackson was right. Civilization cannot tolerate these wrongs being ignored because it cannot survive their being repeated. The attempt to ensure they cannot be repeated, imperfect, politically compromised, selectively applied, and yet real, is what Nuremberg built. It is still being built. The specific mechanics of the Nuremberg trial, how it was organized, how the evidence was gathered and presented, how the defendants were managed, how the different Allied powers' approaches were reconciled, deserve more attention than the summary narrative of its outcomes typically provides. The trial was, in practical terms, an extraordinary organizational achievement conducted under conditions of considerable difficulty, in a city that had been devastated by Allied bombing, in a building that had to be repaired and repurposed while the proceedings were being planned, with four nations that had been united only by their opposition to Germany now trying to agree on legal procedures and standards of evidence that their domestic systems had never had to align before. The American team that assembled the prosecution was drawn largely from the American legal establishment: federal judges, prominent lawyers, academics, prosecutors from the Department of Justice. Robert Jackson, who led the American effort, was an associate justice of the Supreme Court who took leave from the court to run the prosecution. His decision to do so was controversial. Supreme Court justices were generally expected not to take on other government assignments, but Jackson believed the Nuremberg work was important enough to justify the departure from convention. The evidence-gathering effort that preceded the trial was as significant as the trial itself. Allied forces advancing into Germany in the final months of the war had captured enormous quantities of documentary evidence. The meticulous record-keeping of the Nazi bureaucracy, which had documented its crimes in a way that would prove essential to the prosecution. The files of the Reich Main Security Office, the records of the Einsatzgruppen, the correspondence of the concentration camp system, the minutes of the meetings at which the final solution had been discussed and planned, all of this had been captured and was available to the prosecution. The documentary evidence at Nuremberg was so extensive and so detailed that the defense's ability to deny the essential facts of what had happened was limited from the outset. The film evidence was equally significant. Allied forces had filmed the liberation of the concentration camps, the piles of bodies, the surviving prisoners, the physical evidence of what had been done there. This footage was shown in the courtroom at Nuremberg to the defendants and to the world. The effect on the defendants who had claimed ignorance of the camps was visible. The effect on the judges, the press, and the public who saw the footage was to establish, beyond any rhetorical argument, the reality and the scale of what was being prosecuted. The specific logistics of running a trial of the scale and complexity had never been attempted before. The simultaneous translation system that was developed for Nuremberg, for languages, English, French, Russian, and German, with interpreters working in relay to provide real-time translation of everything said in the courtroom, was a technological and organizational innovation that had not previously existed. The headphones that participants wore to receive the translation of a different language were a new technology in this context. The system worked imperfectly and with occasional breakdowns, but well enough to allow a four-nation tribunal to conduct a proceeding in four languages simultaneously. The simultaneous interpretation system developed for Nuremberg became the model for the United Nations and for every subsequent multilingual international proceeding. The press coverage of the Nuremberg trial was extensive and international. Journalists from dozens of countries attended the proceedings. The American press corps included figures who would go on to distinguish careers. Rebecca West wrote about the trial for New Yorker in pieces that were later collected into a book. The trial was covered as what it was: one of the most significant events of the post-war period, the beginning of an attempt to establish a new kind of international order based on legal accountability rather than pure power. The German public's response to the trial was more complicated than the Allied planners might have hoped. Many Germans accepted the general principle of the trial and acknowledged that the Nazi leadership deserved punishment, but the specific legal arguments about retroactivity, about the fairness of a trial conducted by the victors, about the application of a legal standard that had not existed when the acts were committed, found resonance in a German legal culture that valued procedural precision and was not without legitimate grounds for skepticism about some of the legal innovations Nuremberg represented. The German lawyers who defended the accused, men who had themselves practiced under the Nazi legal system and who had therefore their own complicated relationships to the proceedings, made these arguments with professional skill. The defendants' own responses to the trial varied in ways that were revealing. Some were defiant. Göring's performance in the dock was that of a man who genuinely believed he had done nothing wrong and who was determined to make the trial serve his purposes rather than the prosecution's. Some were genuinely broken. Julius Streicher, the virulently anti-Semitic publisher Der Stürmer, who had spent years promoting hatred of Jews in the most vile terms, appeared in the dock as a diminished and pathetic figure whose evident mental deterioration made the question of his culpability more rather than less disturbing. Some attempted the spear strategy of positioning themselves as good men who had been caught in a bad system and who were now, through their cooperation and their remorse, distinguishing themselves from the unrepentant. Wilhelm Keitel, the chief of the High Command of the Armed Forces, represented a specific type: the professional military officer who had signed the orders, countersigned the directives, implemented the instructions, and done so with the efficiency and the discipline of a career soldier who had subordinated his own judgment to the command structure. His defense was a defense of orders, that he had done what he was told, that responsibility lay higher in the chain of command, that a military officer was not in a position to refuse or question the orders he received. The tribunal rejected this defense explicitly. The Nuremberg judgment established that following orders was not a complete defense to charges of war crimes and crimes against humanity, that an individual retained a moral and legal responsibility to refuse clearly criminal orders even within a military hierarchy. This principle became fundamental to the subsequent development of international humanitarian law. The judgment that was delivered on October 1st, 1946, convicted 19 of the 22 defendants. 3 were acquitted: Jalmar Schacht, the banker who had helped finance Germany's rearmament, but who had fallen out of favor with the Nazi leadership before the war; Franz von Papen, the politician whose intrigues had helped bring Hitler to power, but who had distanced himself from the regime; and Hans Fritsch, a radio propagandist whose guilt was considered by the tribunal to be insufficiently established. The acquittals were controversial. The Soviet judge dissented from each of them, and in Schacht's and von Papen's cases, the men were subsequently tried by German denazification courts and sentenced to prison terms, which were served and then commuted. 12 defendants were sentenced to death and executed by hanging on October 16, 1946. The executions were conducted by American military personnel in the gymnasium of Nuremberg prison. They were not clean. The hanging of Joachim von Ribbentrop, the first to be executed, was described by witnesses as badly handled. The drop was miscalculated, and he took more than 10 minutes to die. The subsequent hangings were similarly imperfect. The bodies were photographed, and the photographs were distributed to confirm the executions had occurred. Göring's absence from the gallows, his cyanide suicide in his cell the night before, was a source of genuine embarrassment for the American prison authorities, whose security had been penetrated in a way that was never fully explained. The 3 defendants sentenced to life imprisonment, Rudolf Hess, Walther Funk, and Erich Raeder, were held at Spandau Prison in West Berlin, which became an unusual institution under the joint administration of the 4 Allied powers. The prison was designed to hold multiple war criminals, but its population declined over the years as sentences were commuted. Funk was released in 1957 due to ill health, Raeder in 1955 for the same reason, until by the 1960s Spandau's only prisoner was Rudolf Hess, who remained there until his death in 1987. The 4 Allied powers maintained joint administration of the prison for 1 prisoner until he died, at the cost of considerable resources and considerable political awkwardness, as the Cold War made the required cooperation between the Western Allies and the Soviet Union increasingly strained. The physical city of Nuremberg, which had been chosen for the trial partly because of its symbolic importance as the site of the Nazi Party rallies, and partly because its Palace of Justice was one of the few large intact buildings in the bombed-out German landscape, went through its own post-war transformation. The city was rebuilt in the decades after the war. The bombed areas gradually replaced by new construction. The historic center partially restored. The Palace of Justice, where the trials were held, is still standing. Courtroom 600, where the main trial took place, is still used as a functioning courtroom by the Nuremberg judicial system, and a small museum in the courtroom's anteroom preserves the history of the trial. Visitors can stand in the room where the judgment was delivered and look at the dock where the defendant sat. The Nuremberg trials produced a body of law and a set of precedents that became the foundation of international criminal justice in the decades that followed. The Genocide Convention of 1948, which defined genocide as a crime under international law, was a direct consequence of the legal work done at Nuremberg. The word genocide itself had been coined by the lawyer Raphael Lemkin specifically to describe what the Nazis had done, and Lemkin spent years lobbying the newly established United Nations to adopt convention, making it a crime. The Universal Declaration of Human Rights of 1948 was another consequence. The recognition by the international community in the immediate aftermath of the war that human rights could not be left entirely to the discretion of individual states. The concept of universal jurisdiction. The principle that certain crimes are so serious that any state can prosecute the perpetrators regardless of where the crimes were committed or the nationality of the perpetrators or victims, was another development from the Nuremberg framework. The Eichmann trial was conducted on the basis of universal jurisdiction, and the Spanish judge Baltasar Garzón's attempt to prosecute Chilean dictator Augusto Pinochet in the late 1990s was another application of the same principle. The legitimacy of universal jurisdiction remains contested in international law, but it exists, and it exists because of Nuremberg. The relationship between the Nuremberg legacy and the subsequent history of atrocity and impunity is a complicated one that the legacy's defenders and its critics have assessed differently. The subsequent decades included genocides, Cambodia, Bosnia, Rwanda, Darfur, in which the Nuremberg framework was either not applied or was applied too late to prevent the killing. The International Criminal Court, which represents the institutionalization of the Nuremberg principles, has been criticized for applying its jurisdiction selectively, for prosecuting primarily African leaders while declining to address crimes committed by the citizens of powerful states. These criticisms are not wrong. The Nuremberg legacy has not produced a world that Robert Jackson described in his opening statement, a world in which crimes against humanity cannot be repeated because the legal framework exists to deter and punish them. But the legal framework does exist, even if its application is imperfect. The norms are established, even if they are violated. The institution is in place, even if its jurisdiction is contested and its record is uneven. And all of that exists because in 1945, when the alternatives were summary execution or letting the perpetrators go, the Allied powers chose, in part because Henry Stimson and Robert Jackson insisted on it, to put the Nazi leadership on trial, and to do it in a way that created law rather than just disposing of enemies. The choice was imperfect. The law it created is imperfect, but it was a choice for law over power, and it mattered. It still matters. The prosecution's answer to the retroactivity argument was several layered. At one level, it argued that the acts in question were already illegal under existing principles of international law, that the Kellogg-Briand Pact of 1928, which had prohibited aggressive war, provided the basis for crimes against peace charges even before the London Charter formalized them. At another level, it argued that the acts in question were so obviously criminal, so clearly outside any legitimate conception of what states and individuals were permitted to do, that the absence of explicit prior prohibition did not excuse them. The argument had a moral force that was difficult to deny. If the systematic murder of millions of people in gas chambers is not a crime, because no one had written it down as a crime before it happened, then the concept of criminal law has failed its fundamental purpose. The tribunal accepted these arguments, in effect, by proceeding to judgment. The legal reasoning in the judgment addressed the retroactivity problem without fully resolving it. The tribunal acknowledged attention and concluded that the principle of justice required proceeding despite it. Whether this was legally satisfactory is a question that legal scholars have debated for 80 years. Whether it was politically and morally necessary is a different question, and the answer to that one is clearer. The defendants who sat in the dock at Nuremberg were not a complete representation of the Nazi leadership. Adolf Hitler, Heinrich Himmler, and Joseph Goebbels had killed themselves in the final days of the war. Hitler in his bunker in Berlin, Himmler after capture, Goebbels alongside Hitler in the bunker. Martin Bormann, Hitler's personal secretary, was tried in absentia and convicted. He had disappeared at the end of the war and was not definitively confirmed dead until 1973, when his remains were identified in Berlin. The men who did appear were the ones who had been captured. Hermann Göring, the second most powerful man in the Reich, commander of the Luftwaffe, founder of the Gestapo, Rudolf Hess, Hitler's former deputy, who had flown to Scotland in 1941 in a bizarre solo peace mission and had been in British captivity ever since. Joachim von Ribbentrop, the foreign minister, Wilhelm Keitel and Alfred Jodl, the senior military commanders, Albert Speer, the architect of the Reich's war production, and 18 others, each of whom had played a significant role in the Nazi state and its crimes. The individual cases varied enormously in their character and their outcome. Göring was the dominant personality in the dock, intelligent, combative, completely unrepentant, using the trial as a platform for defending National Socialism and himself with a skill and a shamelessness that genuinely concerned the prosecution. He was convicted on all 4 counts and sentenced to death, but cheated the executioner by taking a cyanide capsule the night before his scheduled hanging. How he obtained the capsule, smuggled past security in a prison that was supposed to be completely secure, remains uncertain to this day. Rudolf Hess presented a different kind of challenge. He claimed throughout the proceedings to be suffering from amnesia, unable to remember the events in question, unable to recognize the people around him, unable to participate meaningfully in his own defense. The doctors who examined him were divided about whether the amnesia was genuine or simulated. His erratic behavior in the courtroom, sometimes appearing completely disengaged, sometimes suddenly lucid and engaged, made the question of his mental competence a persistent issue. He was eventually convicted of crimes against peace and conspiracy and sentenced to life imprisonment, a sentence he served at Spandau prison in Berlin until his death in 1987, at the age of 93. Albert Speer occupies a particular place in the Nuremberg story. The defendant who successfully positioned himself as a good Nazi, a technocrat who had served the regime without knowing the full extent of its crimes, who expressed remorse and cooperated with the prosecution, and thereby distinguished himself from the unrepentant defendants in the dock. His defense was substantially dishonest. Subsequent historical research has established that Speer knew far more about the Holocaust than he admitted, and that his expression of ignorance was a calculated strategy rather than a genuine account of his knowledge. But it worked in the context of the trial. He was convicted of war crimes and crimes against humanity, specifically for his use of slave labor in the armaments industry, but was sentenced to 20 years imprisonment rather than death. He was released in 1966 and spent the rest of his life writing and speaking in ways that continue to manage his public image with the same calculation he had brought to his Nuremberg defense. The trial of the major war criminals at Nuremberg was the first and most prominent of a series of trials that followed in subsequent years. The Nuremberg military tribunals, 12 subsequent proceedings conducted by the United States under the legal framework established at the main trial, addressed specific categories of defendants: the doctors who had conducted medical experiments on concentration camp prisoners, the judges who had administered the Nazi legal system, the industrialists who had used slave labor, the Einsatzgruppen commanders who had led the mobile killing units that murdered hundreds of thousands of Jews, and others in the occupied Soviet territories, the senior military commanders of the Wehrmacht. The doctor's trial, the first of the subsequent proceedings, addressed 23 defendants, including physicians and scientists who had conducted experiments on prisoners at Auschwitz, Dachau, and other concentration camps. The experiment included exposure to extreme cold and extreme altitude, deliberate infection with disease, bone and muscle transplants, and procedures designed to advance Nazi racial theories or military medicine at the cost of horrifying suffering and death for the subjects. The trial produced the Nuremberg Code, a set of principles governing the ethical conduct of human experimentation that became the foundation of modern research ethics, and that is still cited in medical ethics discussions today. The principle that human research subjects must give voluntary informed consent, that their welfare must be protected, that experiments must be designed to minimize harm. These principles were articulated in direct response to the evidence presented at the doctor's trial and have shaped the practice of medical research for 80 years. The Einsatzgruppen trial produced the longest death sentences of any of the Nuremberg proceedings. The Einsatzgruppen were the mobile killing units that followed the German army into the Soviet Union in 1941 and systematically murdered the Jewish population of the occupied territories, shooting them in mass graves, in forests, in ravines, in the specific ways that the documentary evidence presented at the trial described with a precision that left no room for doubt about what had happened or who had ordered it. The 24 defendants in this trial had participated in or commanded operations that killed more than 1 million people. 14 were sentenced to death, though most of the death sentences were commuted in subsequent years by the American occupation authorities, as Cold War politics shifted the priority from prosecuting former Nazis to recruiting useful Germans against the Soviet Union. The commutation of sentences, the release of convicted war criminals in the early 1950s as a political context change, is one of the less comfortable aspects of the Nuremberg legacy. The legal proceedings that have been constructed so carefully, the sentences that have been imposed after deliberate judgment, were modified and shortened by the same political pressures that had shaped everything else in the post-war period. Men who had been convicted of crimes against humanity were released from prison within a decade of their conviction because the United States needed West German cooperation in the Cold War, and West German public opinion was not sympathetic to continued prosecution of its wartime leadership. The West German government's own prosecution of Nazi war criminals, which continued to the 1950s and 1960s and beyond, in proceedings that the German judicial system conducted under its own authority, was at best uneven and at worst a near failure of justice. The denazification process that the Allied occupation had imposed in the immediate post-war years had been, by common consent, inadequately thorough. Former Nazis had returned to positions in the West German government, judiciary, industry, and professions in numbers that made a mockery of the denazification program's stated objectives. The prosecution of specific war criminals in German courts proceeded slowly, faced massive institutional resistance from within the legal system that was staffed in part by people who had served the Nazi state, and produced results that were disproportionate to the scale of the crimes being addressed. The exception, the case that demonstrated what the German judicial system could do when it committed to the task, was the Auschwitz trial of 1963 to 1965, in which 22 defendants were tried in Frankfurt for their participation in the murders at Auschwitz. The trial took years, produced a record of extraordinary detail about what had happened in the camp, and resulted in convictions for most of the defendants. It also galvanized a generation of young Germans who had grown up in post-war West Germany and who, through the trial's proceedings and the coverage they generated, confronted for the first time the full reality of what their parents' generation had done. The 68 generation of West German political culture, the student protest movement of the late 1960s that challenged the political establishment and its relationship to the Nazi past, was shaped in important ways by the Auschwitz trial and the questions it forced onto the national agenda. The Israeli prosecution of Adolf Eichmann in 1961 represents a different kind of reckoning with the Nazi crimes, one conducted not by the Allied powers or by the German state, but by the state that had been founded in the aftermath of the Holocaust and that claimed a specific relationship to its victims. Eichmann had been one of the primary architects of the logistics of the Holocaust, the bureaucrat who coordinated the deportation of Jews from across Europe to the death camps with the efficiency of a competent administrator. He had escaped to Argentina after the war and was living there under a false identity when Israeli intelligence agents abducted him in 1960 and brought him to Israel to stand trial. The Eichmann trial was controversial in its method. The abduction from Argentina violated international law, and Argentina protested formally, but it produced something that Nuremberg had not fully produced, a sustained public account of the Holocaust from the perspective of the survivors. The prosecution brought survivor witnesses to stand in a way that Nuremberg had not emphasized, and the testimony they gave, the specific, detailed, personal accounts of what had been done to them and to the people around them, reached a global audience through television coverage in a way that the Nuremberg proceedings, conducted a decade and a half earlier before the age of television, had not. The Eichmann trial created a specific public understanding of the Holocaust as a human experience, with victims who had names and faces and memories, rather than purely as a historical and legal abstraction. Hannah Arendt's coverage of the Eichmann trial for The New Yorker produced one of the most influential and most contested pieces of political philosophy of the 20th century. Her concept of the banality of evil, the observation that Eichmann was not a monster, not a sadist, not a man driven by hatred in any conventional sense, but a bureaucrat who had committed his crimes to the ordinary human failure of not thinking, of subordinating his judgment to the demands of his institutional role, disturbed and challenged many people who had expected the architect of the Holocaust to look different. Whether Arendt's analysis of Eichmann was accurate, whether his claims of mere bureaucratic obedience were genuine or calculated, whether the evil he represented was genuinely banal or genuinely monstrous in a way that the banal evil framework obscured, is a debate that continues among historians and philosophers. What the Nuremberg trials and proceedings that followed them established, in aggregate, was a legal and moral framework that changed the world in ways that their architects could not have fully anticipated. The principle of individual criminal responsibility for crimes against humanity, the principle that Stimson and Jackson and their colleagues insisted on in the face of easier alternatives, became the foundation of international criminal law in the decades that followed. The International Criminal Tribunal for the former Yugoslavia, established in 1993 to address the crimes of the Balkan Wars, and the International Criminal Tribunal for Rwanda, established in 1994 to address the genocide there, were direct descendants of the Nuremberg framework. The International Criminal Court, established by the Rome Statute of 1998 and in operation since 2002, represents a permanent institutionalization of the principle that individuals can be held criminally accountable for genocide, crimes against humanity, and war crimes regardless of their official status or protection of their governments. The Nuremberg legacy is imperfect and contested, as all legal legacies are. The victor's justice critique, the argument that Nuremberg was powerful nations imposing their own legal standards on a defeated enemy, with no account for the act of the Allied powers themselves, has never been fully answered because it has never been fully wrong. The Allied conduct of the war included acts that the Nuremberg framework would have difficulty distinguishing from war crimes. The strategic bombing of German and Japanese cities, the use of nuclear weapons against civilian populations, the Soviet treatment of German prisoners of war. The Nuremberg tribunals did not address these acts, and they were right not to. The trials were specifically about the Nazi crimes, not a comprehensive audit of Allied conduct. But the selectivity of the proceedings is part of the legacy and should be acknowledged. What the trials accomplished, despite their imperfections, was something that human history had not previously managed. The public, deliberate, documented judgment that specific acts committed by specific people in positions of power constituted crimes against humanity for which those people were personally accountable. The documentation of the trials produced, the evidence gathered, the testimony recorded, the judgment written, created a historical record of the Holocaust and the Nazi crimes that could not be denied or undone. It was not comprehensive. It was not complete, but it was there in writing, with the force of a legal proceeding behind it, for everyone who came after to read and to reckon with. Robert Jackson, the American chief prosecutor who delivered the opening statement at Nuremberg, a statement that remains one of the most powerful pieces of legal rhetoric in the English language, said in that statement something that has been quoted and requoted in the decades since. The wrongs which we seek to condemn and punish have been so calculated, so malicious, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. He was right. The attempt to ensure that they could not be repeated, flawed, incomplete, politically compromised, and yet fundamentally necessary, is the Nuremberg legacy. It is worth remembering. It is worth understanding. And it is worth defending against the forces that would prefer it to be forgotten. The specific way that the Nuremberg trials shaped the concept of state sovereignty is worth a final consideration, because sovereignty was one of the fundamental principles of the international order that Nuremberg challenged. The traditional conception of sovereignty held that what a state did to its own citizens within its own territory was a matter of purely domestic concern. that other states had no legitimate legal interest in how a government treated its own people, and that the concept of international law applied only to relations between states rather than to the internal conduct of states toward their populations. Nuremberg challenged this conception directly. The crimes against humanity charges established that there were acts so extreme, the systematic persecution and murder of civilians on the basis of race, religion, or political affiliation, that they constituted violations of international law regardless of whether they were committed by a state against its own citizens. The principle was not universally accepted when it was first articulated, and it has been contested ever since. But it exists. It is part of international law, and the tension it creates with the sovereignty principle. The argument that respect for sovereignty sometimes requires tolerance of atrocities that sovereignty shields from external accountability remains one of the central debates of international politics. The responsibility to protect doctrine, adopted by the United Nations in 2005, establishing that the international community has a responsibility to protect populations from genocide and crimes against humanity when their governments fail or are themselves the perpetrators, is the most recent development in the trajectory Nuremberg began. Its application has been imperfect and politically contested, but it exists because of Nuremberg. The men who sat in the dock at Nuremberg in 1945 were defending themselves against charges they considered illegitimate, in a proceeding they considered unjust. They were wrong about the charges and wrong about the proceeding. The order being created around them, imperfect, contested, incomplete, and yet real, is part of the world we live in today.